Chapter 28. The Police and the Court. It is the duty of our government to protect our rights and provide us security. To discharge this duty, our government has set up a vast network of police departments. Every state and union territory has a network of police. There is a police station in every big neighborhood and in every big village. Besides providing safety and security to people, the police department maintains law and order in society. Police also help the judiciary system by preventing crime, investigating crime, and upholding the law. Hierarchy in police department. A district is divided into 5 or 6 subdivisions, each under the charge of a deputy superintendent of police. There are about 10 police stations or thanas, which are under the charge of an inspector of police. The sub-inspector, assistant sub-inspector, head constable, and constables work in each police station. The police appoints chowkidars in villages. They help the police to detect crimes and arrest the culprit. Supreme Court guidelines for the police. The Supreme Court has also issued certain guidelines to the police in order to protect the fundamental rights of the citizens. Some of these guidelines are: the time, the place of arrest, and the venue of custody of the person accused should be noted by the police. If the relatives of the accused do not reside with him, then the police should inform the relatives through a legal aid organization. The accused should be made aware of his rights immediately after the arrest. Article 22 of our Constitution also guarantees certain rights regarding protection against arrest and detention in certain cases. Some such rights are as follows: the right to be informed of the reason for arrest at the time of arrest, the right to be defended by a legal practitioner of his choice, the right to be produced before the magistrate within 24 hours of arrest. First Information Report. The First Information Report, FIR, is the information recorded by the police officer on duty. Where to file an FIR? An FIR can be filed in the police station of the concerned area under whose jurisdiction the offence has occurred. How to file an FIR? A proper procedure to file an FIR is as follows. The informant meets the officer in charge at the police station and narrates the sequence of events. The officer writes down the complaint and it is signed by the informant. The information given is then entered in a book to be kept by the officer. A copy of the FIR is given to the informant. In an FIR, the following details are noted: the date and approximate hour when the crime was committed and reported, the place where it occurred, the name and address of the complainant, the name and address of the suspect, if any, description of the crime, in case of theft, details of property stolen, the section of the law which applies to the offence. Right to Information Act 2005. To increase the transparency in the government department, the Right to Information RTI Act was enforced on 12th October 2005. This act gives Indian citizens the right to demand information from public authority. The citizens, as per the act, have the right to look into the documents and records to check and verify the work done. They can also acquire the information sought in any form. Process of criminal justice. The court cannot act until or unless the case is brought before it. When a victim makes an appeal, only then the court acts. The procedure of a civil case and a criminal case is different. For example, in matters of family and property disputes, the involved parties approach the court and the court settles the matter. However, in criminal cases, the following procedure is adopted. The victim files an FIR. Once the FIR is filed, the police begins the investigation. It examines the crime scene, questions the witnesses, records statements, conducts a search, and collects evidence. It also interrogates the suspect and, if needed, arrests the suspect. After the investigation, if the police finds sufficient evidence against the accused, it arrests him. Then the police files a charge sheet in the magistrate's court. After the charge sheet has been filed, the trial begins. The accused is given the opportunity to defend himself. He can hire a lawyer of his choice to defend the case. This lawyer is known as the defense lawyer. The lawyer who presents the complainant's case known as the public prosecutor. The court awards punishment to the accused only when it has sufficient evidences to prove the accused guilty. Role of the defense lawyer. The defense lawyer appointed by the accused presents the case on behalf of the accused. The defense lawyer can cross-examine the witnesses and also ask the court to summon witnesses to prove that the accused is not guilty. Role of the public prosecutor. The public prosecutor presents the case of the complainant and is appointed by the state. The public prosecutor presents all the facts, evidences, and witnesses before the court to prove that the accused is guilty.